All right, perfect. I think we are already close to 50 attendees. I'm sure this number will continue to go up, but just to be fair to the people who joined on time, I think it's just best that we start. For some of you who may not know me, my name is Adit Puri. I'm the country lead for APACMed in India. And I would like to welcome you all to this very special webinar on data protection and laws and acts, um, with a special focus on the medtech sector. I would also like to welcome Ikigai Law and the team and thank them for partnering with us for this event. A lot of you have seen this act evolve and evolve and evolve like me over the past 3, 4 years. And I've always wondered when it'll stop and how do you really say that it's there, this is what needs to be done. Seems like to be a very moving target. And I think that's one of the reasons why we wanted to sort of have this discussion and hear from an expert to actually help us to decode and understand where things are at this point in time, with a special emphasis on our sector. So, in short, when this act came into being a few years ago, it was a long overdue milestone. But however, the critics say that it's become a technical nightmare, and it's important to sort of understand what are the sort of the technical characteristics, or at least understand some of them to help us have a working knowledge in order to deal with data protection, sort of personal data, and as well as privacy as we go around in our day-to-day businesses. The other point that I want to make is that, of course, this is in the spirit of what APACMed India has been doing. We organized, and we've already organized two digital health summits. The first one that we did was around regulatory pathways for digital health products. The second, and there was another part to this was around reimbursement for digital health technologies. Late last year, we also did a health summit which focused on AI and it focused on data privacy as well. So I would like to sort of continue our thinking and our attention to the subject because we definitely feel with AI, with India's healthcare trajectory transforming and telemedicine, this is definitely a space which continues to evolve. So on that note, I would also like to introduce our speaker for today. So Srinidhi, welcome. Srinidhi Srinivasan, who is a partner at Ikigai Law, is going to be leading the session today. Essentially, she heads the firm's data practice. She also, of course, advises world's leading technology companies on data privacy issues, and is recognized as a lawyer known by publications like Legal 500 as the next generation partner, right? And she continues to speak at conferences and authors pieces in India's leading publications. So, Srinidhi, I would like to welcome you and would request you to take forward the conversation from here.
Great. Hi, everyone. Thank you so much for that introduction, Adip, and to the whole APACMed team. Thank you for having us here. Good afternoon, everyone. Over the next hour or so, my colleague Bobby and I will walk you through some of the key aspects of this law. Some of you might have already heard about this law. Like Adip said, it's taken a while to get here. The act has really seen 4-5 iterations, and even now that it's on the statute books, there are implementing rules that are still awaited under the law, though we've seen one draft version of that. So we've picked out a few key themes that we want to go over with this group, specifically drawing out examples and case studies on Medtech. I think I'd request everyone, I think you'll all be on mute, but if you have any questions along the way, feel free to type them in the chat function, and Bobby and I will take those up along the way, and we'll also reserve some time at the end to take up any remaining questions. With that, I think I'll jump right in. I think the broad themes that we're looking to cover are, I'll give you a brief overview of where we are at currently, what the status of the law is, status of the rules is. Because some of us are from global communities, we'll also speak a little bit about what are peculiar considerations for global businesses. And after that, we've picked out a few key themes. There is a lot in the law. I could go on and on. Like we've done one-day workshops digging into specifics of each of these, but we've picked out a few that we thought would be most relevant, most interesting to this group. First of those will be structuring your arrangements with different entities in the ecosystem. Are you a fiduciary? Are you a processor? What's your role with respect to the data and with respect to the end user? We'll speak about data breaches. That's a key theme in the law and slightly peculiar requirements in India's law. We'll speak about use of publicly available data because that's an exception that's been granted to us in the law, particularly relevant for AI businesses. We'll talk about notice, consent, legitimate uses, retention and deletion obligations, and we'll speak about significant data fiduciaries because it's likely that anyone who's processing a large volume of sensitive data like health data could also be governed under this. With that, I think I'll start with just a brief overview of the law and the situation currently. So this act was enacted in 2023 of August. It's yet to be brought in force. The government is yet to notify it. It could have a phased implementation. The reason that it's not yet notified is that there are still some implementing rules under the law that are awaited. The law is principle based, so it sets out the principle. For example, it will say if you are processing data, you must provide a notice and get users' consent. But the specifics of that notice is something that will be laid out in the rules. Those rules are still awaited. There was a draft set which was released for public consultation in Jan of this year, and there was a window where MeitY conducted a series of consultations across cities and received a lot of feedback on the draft. They are taking on board all of that feedback and are likely to notify and publish the final set over the next couple of months. There's an enforcement authority that is set up under the Act and the rules. So it's likely that once the Act and rules are notified, those are the provisions that will kick in immediately. And after that, several other requirements, there could be a phased implementation. It's possible that this is, 2 years. It could be lesser than that as well. Really, what the Act and the rules do is affect businesses across three threads. One is wherever you have touch points with an individual, either you're a B2C enterprise or even where you're a B2B company predominantly, where a lot of medical device manufacturers might be, but wherever you have a touch point with an individual, wherever you're collecting data or controlling the data directly, there'll be requirements around, what the UI UX looks like. You'd have to reevaluate how you're providing individuals notice, showing your privacy policy and taking their consent. Also means reviewing your user terms or privacy policy. So anything that is front end, user facing or individual facing. The second is the back-end processes, which is really what we call getting your house in order. This would be evaluating at the back end how you're collecting, storing, processing, using data. Often the starting point for compliance is creating a data inventory or a data map so that you can figure out what is really the data that you're collecting and then certain gaps and help look towards bridging those gaps from the law. And the third is your third-party relationships. This is relevant for whether you're B2B, B2C, really ascertaining how you're sharing data with third parties, how you're receiving data from them, what's your relationship with them, are they controlling the data, are you controlling the data, what rights do you have, what rights will users have if you're only a processor or a service provider to another entity like a hospital, what's your role? So evaluating each of these requirements and then negotiating those agreements, structuring those agreements with third parties, capping your liabilities. So this is the broad framework of how one would approach compliance. Particularly for global businesses, there are a few considerations that I thought might be relevant to this group. Now, for anyone doing business across the globe, there are really, over 100, 150 data protection laws in the world. Honestly, India is a bit late to the party with a standalone data protection law because there are many that are already in place. I'm sure a lot of you have heard GDPR. It's triggered a whole host of changes to websites and cookie policies really across the world. So for a lot of global businesses, their journey would look, to look at actually identifying their key markets, identifying their strategic priorities, evaluating each of these laws, and then determining what their common minimum baseline should look like. Interestingly, there are many differences in each of these laws. While every data protection law is hinged on some key principles, those principles are transparency or purpose limitation or security, data minimization, but the way that these are implemented have differences. A prominent example for India is that under GDPR and many other data protection laws in the world, whenever there's an instance of a data breach, you are only required to report it to the regulator and to the individuals if that breach has a propensity or likelihood of causing harm to an individual. But under India's data protection law, once you designate something as a breach, you'll have to go ahead and report it both to the regulator and to the individual. So that's a key difference. And for a global business, then if in Singapore there's a harm threshold, if in Australia, if in a GDPR there's a harm threshold, but in India there isn't a harm threshold, then you'd have to be careful that if there's a breach involving Indian residents' data, that one has to notify them as soon as you designate something as a breach. Similarly, there are sector-specific laws as well. Our RBI, our Drugs and Cosmetics Act, IRDAI, each of these govern different aspects of different kind of sectors, and different kind of sectors, and that would mean that you have to comply with that as well. And this is true not just for India, but globally. So the first consideration really for global businesses will be to identify what are the key laws that apply to them, and then identifying the common minimum baseline and where there are differences that are relevant to them. The other big theme is around cross-border data flow restrictions. Gradually, over the last couple of years, there have been, inclinations and instances of data residency requirements, or at least restrictions on cross-border data flows. Famously, GDPR had a huge, concerns around data that was flowing, EU residents' data flowing into the US, and similarly to other regions as well. And there are many checks and guardrails to that. Under India's law, though, transfers are allowed broadly to any country, except to countries that have been blacklisted by the government. I mean, it doesn't use the word blacklisted. I'm just using that in a more kind of colloquial context, but it says any country that's notified by the government. So as soon as there's no notification as yet, but if the government were to come up with a list of countries to whom data can't be shared, it would be important for any organization that's doing business in India to be mindful of that. Typically, these are only likely to be countries with whom India doesn't have great relations. So wherever we have trade, diplomatic ties, it's unlikely that those countries will be on the list, but definitely something to keep an eye out for, especially because the rules also say if you're a significant data fiduciary, which is the criteria, we'll class of entities that's processing large volumes of data. For those, there may be additional restrictions that are imposed on localizing data. The third consideration that we've seen global businesses really pick up is there's an exception for if you're a GCC, if you have a back office or operations in India. For example, let's say if it's it's a Singapore group company, but it has another partner or a back office in India, which is, let's say, assisting in processing payrolls of the Singapore companies. Employees pursuant to an agreement with a Singapore company. There is an exception in the Indian law for this, because the assumption here is that it's Singaporean law and those requirements will translate and cascade downstream in the contract with the Indian entity. So the Indian entity will be exempt from some of these requirements. This exception was really geared towards boosting India's ITES industry. So this is something to be mindful of if you're doing operations business in India and there are intra-group sharing agreements that you're setting out. So this is really the lay of the land and what additionally global businesses should watch out for. Now I want to come to the specifics, and I'll just pause to see if there are any questions so far in the chat. Bobby, anything? And again, a request to people: if you have questions, please drop them in the chat. for us, we'd be happy to take those along the way just to make it more, engaging and topical.
Thanks, Srinidhi. I think there's just one question that has just come out, which is for any GCC exception, is there any requirement to qualify for this? Should India sign should the Indian entity sign an agreement with the Singapore entity under the same parent?
Yes, the Indian entity will be required to sign an agreement with the parent. The exception only applies if you're processing data under a valid contract with the parent company. And the assumption would be that in that contract, how you define how you're processing data, what are checks, what are security safeguards, all of that will be baked in. So if you have a contract in place which is setting out all these requirements, then you'll be fine. You'll be eligible to claim that exemption. There are no other details provided on what are the specific aspects in the contract, but broadly, I think the classic themes that one would find in a processor, fiduciary, controller, processor contract when one entity is asking another to service it's to process data on its behalf. Those clauses, if you have, you should be good.
That's it for now, Srinidhi. We can proceed.
Okay. Great. So now we'll really come to the meat of some of these conversations. So the first piece there is how do you structure your relationships and agreements? So the law sets out these different entities. The first is the data principle. Data principle is any individual whose data is collected. In many global laws, this is called the data subject, but India has chosen to go on with the framing of principle because the idea is you should be able to control how data about yourself is out there in the world. The second entity, and really this is the entity on whom the entire force of the law is and all obligations are, is the data fiduciary. This is the entity that is determining purpose and means of data processing, which means it's calling the shots with respect to that data. It's directing and controlling the data processing. It is deciding what data to collect, whose data to collect, how would you determine, how would you process it, how long to retain. It's really the entity which is dealing with the individual either directly or through a vendor, but the crux of the law is that this is the entity whose neck is on the line. In contrast, there are also data processors recognized in the law, but these are entities that are only processing data on the instructions and on behalf of the data fiduciary. They are not making independent decisions around the data. While a lot of times data processors may also be evaluating means of processing. For example, let's say in an let's say a background verification kind of context, but even if the processor is deciding how to collect that data, how to vet it, whom to have downstream sub vendors and all of that, even then the final deciding authority, controlling authority for all of this is the fiduciary. So that's how the law is structured. Neck on the line, fiduciary only. Processors, there are no obligations. There's also another class of entities called significant data fiduciaries, but we'll come to that here. These are entities that are notified by the government because they're processing large volumes of data. But I want to take a few examples that will help clarify the controller or rather fiduciary processor distinction. I'm using the word controller often because controller is what data fiduciaries are known around the world, but the phrase in the Indian law is of fiduciary. So let's take this first example where a hospital has a patient monitoring device in its ICU. Now, this device is collecting a lot of patient vital signs. It's uploading them to to a secure cloud. Hospital decides what data, how it's going to be used, what it's going to be used for. The manufacturer, the device manufacturer, is maintaining and holding all of this infra, and maybe making some minor decisions also about where it's stored and how it's stored and all of that. But eventually, it's kind of acting on the hospital's instructions. So hospital is the one which is deciding what to use it for, how to use it, whose data, which are the patients that this will be used on, and the manufacturer is but providing that infra. So I think this is a scenario where it's straightforward, where the hospital acts as the data fiduciary, even though there is a lot of data that's being processed through the device, and maybe the manufacturer, and there's a software to it, is also able to access the data, or rather process the data on behalf of the hospital. Because all of this is happening on behalf of the hospital, the device provider would actually not have any access to this data if not for the hospital. This is a fiduciary processor arrangement, and it would be important then to recognize it as such. The hospital would have to set out these clear do's and don'ts on what can be done with the data, what can't be done with the data, and when to delete, how to retain, what to do with it. All of that is really the hospital's prerogative, and the law will hold the hospital responsible for this. Another example is, let's say, if the same hospital and the device manufacturer are now actually jointly designing a trial. There's a new diabetes monitoring device. You are making decisions together. It's a bespoke product. Here you're jointly agreeing on what the study methodology would be, the protocols would be, who are going to be the people whose data will be used for this, how patient data will be used for research, for collection, and both parties are essentially making decisions jointly. Now, this is a scenario where it's not as though one is acting on the instructions of the other as such. So this becomes a scenario of a joint fiduciary relationship. Here, even the device manufacturer is making important decisions around the data alongside the hospital. So it would be important to call it out as such in the agreement. So here we often also get the question on, does Indian law recognize joint fiduciaryship? Unlike GDPR and some global laws where there are actually specific sections for joint data controllers, India's law doesn't do that, but it does say that data fiduciary is anyone who is making decisions about purpose and means, either by themselves or in conjunction with another entity. So there is an implicit recognition that there could be joint fiduciaries as well. And it would be important then to structure the relationship like that. The third example is, let's say it's a medical device company. You've sponsored one research study. You're collecting patient data for this purpose, and you're directly getting it from participants using the device. Now, you may have you're working with a hospital to do this study, but actually in this scenario, you've just told the hospital, hey, this is the data set that I need. Can you collect from your patients? Of course, subject to all consent requirements and everything that you're doing, but follow our instructions. These are the kind of people that we need it for. This is the kind of how long we'll store it, we'll tell you. And essentially, it's where the medical device company is going to use this data for its own purposes. The hospital, of course, is anyway, it's patient care. So in the ordinary course of that patient care, whatever data they are collecting is their own business. But in this particular processing activity, they don't have a role beyond only agreeing to only following what the company is saying, only kind of following the sponsor's instructions here around data processing. So this would be an example where it's actually the other way around. It's the device company is the fiduciary for this clinical trial, and the hospital is acting as a processor. The hospital definitely is also an independent data fiduciary for any other data that it's collecting about the patient. But in the specific context of this clinical trial, it acts as a processor. Now, these are slightly, there could be many variations to this. So fiduciary processor distinction is not at an entity level. It is not as though once you are in one situation, you are a fiduciary, you will always be a fiduciary. That's not the case. You could be wearing multiple hats throughout, depending on what you're doing. Like in the first example, when you're only providing a device that the hospital is deploying further, you may only be a processor. But if you start using that data, let's say it's a wearable device, you're also deploying it to end users directly, there you are a fiduciary. Now, if you're instructing the hospital to collect some data on your behalf, you become a fiduciary again. So it's kind of, you could be wearing multiple hats, but it would be important then to look at each of those activities. I'll pause because I see a bunch of questions. Bobby, any that you want to pick up and send my way?
Yeah. So I think maybe we can start, because you're already on case study 3. We have a question on who is the data owner in this scenario in case study 3.
Who's the data owner in the case study 3? Here it's the device company. I mean, I've given a simplified example. In real world context, of course, there could be more nuance, but in this kind of an example, it's like the device company has started this entire process and are running the trial, and they have kind of, it's like their proprietary data set. I will say though that this concept of ownership with personal data, there isn't really, it's not as though one can say that the data belongs to the individual. It's more about one having rights over that data. But I think in this example that I've set out, it's kind of like, the device company is controlling, owning that data set. The hospital doesn't have any independent rights on this.
Thanks for that, Srinidhi. There are a couple of other questions. I'll just pick one of those again. So the question is, in general, if a global company is compliant with the GDPR, what would it need to do differently to be compliant in India? A high-level response would be good.
Sorry, could you say that again? Company is compliant.
Yeah. So if a global company is compliant with the GDPR, what would it need to do differently to be compliant with the Indian laws?
Right. So there are a few key differences that the Indian law has from the GDPR. I'll list out a few. One is just on the basis for processing. GDPR has 6 legal bases identified. One is consent, one is contract, one is legitimate interest of a business, and so on. Indian law has one major ground, which is consent. There are also 9 legitimate uses that are specified in the law, but there are none that correlate to contract or actually to legitimate interest. So I think one key consideration is, if you're grounding something in contract or if you're grounding something in legitimate interest, then finding what that appropriate legal basis for processing would be in Indian law. The second would be around data breaches. GDPR has a risk-based threshold for breaches, which is that if you are notifying, there's a data breach that you've experienced, but you are only required to notify individuals if there is likelihood of serious harm to the individuals. Unlike that, in India's data law, you must notify in cases of all breaches. There's no risk threshold set out. The third is around parental consent. Now, I don't know how relevant that might be in the healthcare context, but this is also a key difference that in Indian law, it requires you that whenever you're collecting children's data, you must get their parents' verifiable consent. GDPR also has some consent framing for children. Children are, of course, different member states can decide who children are. 13 to 16, there's a range. In Indian law, it's 18. So if you're collecting data from anyone below 18, you have to get their parents' verifiable consent. Rules are specifying those modalities and specifics. It could be that, there's something more that one does just one has to do beyond just having a self-declaration. So processing children's data is a big piece. Another piece is on publicly available data, and that's something we'll come to, that there is an exception in Indian law for when you're processing publicly available data. Maybe I'll pick that up when we're doing the discussion. But yeah, just on a high level, a few big prominent themes on really what the difference is. So kind of automatic, if you're complying with the GDPR, it would not mean automatic compliance with DPDP, but at least you'll have the structures in place, and it will be some specifics that one has to then iron out for India.
Thanks for that, Srinidhi. Perhaps we could do just one more question. This is specifically with respect to the first example, on the first hospital example. The question is, if the device manufacturer, who's the processor, is further using any third-party service provider like a cloud services. In such cases, would this third party be referred to as a data processor or a sub-processor? And does the Indian law recognize the concept or any obligations for sub-processors?
So the Indian law doesn't mention sub-processors as such, but the understanding is, if the fiduciary has, asked the processor in that agreement itself, there also usually clauses around whether you can appoint sub-processors, who those sub-processors can be. Typically, I think what market practice has become is that you will have a list of approved sub-processors in the agreement, and if there's anyone outside of that list, then it's either a prior consent requirement or it's a notification, and you provide us notification, and if we don't object, you can go ahead and appoint that sub-processor. I think that will also depend on what the structure is. In this example, I don't think there's anything barring the it's essentially the hospital is telling the device manufacturer, you figure out everything, including, cloud storage. Here's a list of approved entities that you can use, and it'll be structured as a sub-processor setting. To the individual, though, it is still the hospital that will be directly liable, even if it doesn't have a direct agreement with the device manufacturer. Sorry, with the cloud service provider.
Thanks for that, Srinidhi. There are actually a bunch of other questions that have just come up. Would you like me to take one or two of them?
Yeah, if they relate to this, the 2-3 topics that we've discussed, I think we can go ahead.
Sure. So one question is, in case study 1, if the medical device company uses patient data to improve quality or develop next generation devices, how should the arrangement be structured?
Yeah. So this is a question that I didn't put in, but definitely something we've discussed and deliberated a lot, because the moment actually that you start using the data for your own purposes, you are controlling the data. You're deciding the purpose and means of that. Typically, I think how this would play out is that in the agreement, perhaps you reserve a right to use anonymized data for your own purposes. And the assumption then is that once it's anonymized, all of that data is not personal, anonymized to an extent that it's not going to be, you're not going to use it for re-identification of individuals. It's more for, let's say, bug fixes or problems that are eventually relevant to service improvement. So potentially I see this as something that's addressed in the agreements. Maybe this might also depend on the context. I think this kind of patient monitoring device, let's say if it's a setup that the individual also has to do. Maybe let's say, I don't know, my hospital has given me maybe a glucose monitoring device, but there's a setup layer, and for that setup and sign up, I do go back to the device manufacturer. Maybe if the device manufacturer there is also taking additional consent, and saying that we might use your data for multiple different, purposes. If there is that opportunity for getting that notice and consent, there, the device manufacturer then wears the hat of a fiduciary who's then using some of this data for their own purposes. But the moment you start using it for your own purposes and improvement, and maybe something beyond what the service delivery is speaking of, then you wear the hat of a fiduciary. Okay. Maybe, Bobby, in the interest of time, I'll actually move to the next themes, and maybe some of the questions we can come back to at the end on these themes.
Sure.
Yeah. Just to maybe close the fiduciary processor piece, it's on who's controlling the data processing, it's who's making significant decisions around it, using it for your own purposes, or only using it on the instructions of the company. And like I was saying, so the Act places the entire onus of processing on the data fiduciary, nothing on the processor. Which means that if you want to require the processor to do anything, you have to do that under the Act. The implicit understanding, actually, it's not implicit, it's called out that you can only engage. You can ask processors, as a fiduciary, you can ask processors to process data on your behalf, but it has to be under a contract. It doesn't set out what all the contract should include, but typically these are the clauses that we'd see in contracts. You would recognize the party's role, you define what the specific task is, what you can do, what you can't do. You'll specify the security controls, you'll say what is the processor's liability in case of a breach. You'll have indemnities for breach, very important. You'll have breach notification requirements, approval or notification rights for sub-processors, audits, deletion requirements, assisting, ask them to assist you in responding to data principals or to supervisory authority. So typically we'd see all of these set out in the agreement. The next big theme is, once you establish what your role is, how and when what do you really do? How do you process data? Now you can process data under 2 threads, and I think I was mentioning this when responding to that GDPR question. The 2 threads are, either you give users a notice and take their consent, or you're using the data for one of the 9 legitimate uses provided in the law. So let me first broadly speak of notice and consent. Notice has to be a document that's setting out what data you collect and why, how individuals can complain, to the board, how individuals can exercise their rights. Notice has to be provided in English and at the option of the user in other Indian languages as well. And once you give users that notice, they have to then give you consent, which you will have to justify as free and specific and informed and unambiguous. So there has to be some purpose calling out, which is very clear. There has to be consent, has to be through an affirmative action. It can't simply be inferred by by inactivity, especially, and has to be accompanied with this notice. There are a few additional requirements in the rules, which is that the notice should be in clear, plain language, understandable independently of other information. It should have an itemized description of the data, the purpose, and the services. So, a lot of privacy policies today often have this section broadly, which will say, here's the data we collect, and here are the purposes, which is a laundry list of purposes. But this is really calling for a connection between the two. If I'm doing this, then this is the data that I collect, and this is what I'll be using it for. So a clear call out in the privacy notice, not simply laundry lists or no longer the approach of let's just stuff it in the privacy policy. Then in the notice, you must also provide a link where users can use and withdraw their consent, exercise their rights. So really what this would mean is revisiting platform UI wherever you have a user-facing interface. Simply linking privacy policy may not work. Laundry list of purposes may not work. So reviewing the platform UI to make better design choices. Now, just a couple of examples of what this might look like is, so of course, we're all familiar with cookie notices. I think we're bombarded with cookie banners and cookie modals. But I think even in India, currently, a lot of websites have very basic cookie notices, which you can simply ignore. But I think very likely what will happen once this act is in force is maybe not as granular or as in-depth as EU cookie notices, but you'll definitely have to call out the purposes, because wherever cookie data is also personal data. So some kind of a categorization that these are functional, marketing, essential. Essential, you can if you don't have the essential cookies, then you can't provide the functionality of the service. But wherever it's marketing or any other purpose that is not critical to the core purpose, you may have a problem having this on by default and may need to justify, allow users the right to opt out of this. So this is just to give you an example of what might not work. Like, a very, very broad catch-all that by signing up, I agree to the terms and there's just a field for entering a number and nothing else. This may not work. And you'd have to provide some more detailing either on the UI itself or through some pop-up intermediate screen that comes there, and you're telling the users exactly what data you're going to be using and how you're going to be using it. And also maybe pre-tick checkboxes where there's too much of an assumption that you're making, because then there may not be clear affirmative action of the user. That might also be a concern. So we do think there's a lot of room to play around with platform UI, thinking of layered privacy policies or pop-ups that are coming on the UI itself, rather than a user going to another link and going to a privacy policy, then going to another control setting. So more careful choices on the UI. And these are just the other legitimate uses. So one is, of course, consent. The other is a legitimate use. So the important ones here are often, there isn't one catch-all umbrella one like GDPR's contract or legitimate interest, but it's when a user is voluntarily providing data. So if I walk into a pharmacy and say, send the receipt to my number and give my number, that should be fine. But that same number can't then be used to send me marketing communication under this. That would require a consent. There are other legitimate uses, like in medical emergencies, in treatments during pandemics and other public disasters, government benefit and so on, that are also used, but may have, because they're more exception-based processing. So a lot of this kind of falls back on notice and consent. So just a few examples. If you're using app crash reports and let's say usage patterns to fix bugs, typically this is something then that should be disclosed in the privacy notice itself, and users read this and then are saying okay to this. Or let's say a scenario where you're a device manufacturer and you have access to some data, but police or law enforcement comes knocking. There, of course, you're allowed to share the data. You can't be expected to go back and take consent of the user. Similarly, any company that's collecting, let's say, bank account details of employees or PAN numbers for payroll processing, that's allowed. There's no requirement for having separate consent there because employment purpose is one of the exceptions to consent. So that's really on the grounds for processing. Now, maybe I'll pause again for a quick sort of 2 minutes to see if there are any major questions on this.
So there are a couple of questions, Srinidhi, specifically, although on the previous slide on case studies. One of those is, in case a consultant does the research and shares the information to the medical devices company, will the device company also be the data fiduciary?
Yeah, they will be. As long as they are controlling and directing the data, the consultant's role is, if it's only limited to collecting data for this device company, in fact, the device company must make sure that the consultant is not using it for any other purpose.
There's just one more on whether medical data of Indian patients need to be stored in India, or can it be stored outside on cloud?
Yeah. So there's no specific embargo. You can store data elsewhere freely, but there can be sector-specific requirements. The government, through rules, can say you can share data with this country, can't share data with this country. And there could also be, if you get tagged as a significant data fiduciary, the government could say this kind of data you must store only in India. There can also be sector-specific laws. I recall that a while back, while this never saw light of the day, but e-pharmacy draft rules, they had said that any data that you're collecting has to be stored in India, patient data. So, one must keep an eye out for those kind of sectoral requirements as well. But under the data protection law, no such general rule.
Thanks for that, Srinidhi. There's one more on whether employment is a legitimate ground under the current SPDI rules. If not, does it mean that company is now required to take consent from the employees till the DPDP Act is in force?
Yeah, so there isn't an employment purpose ground specifically in the SPDI rules. So the assumption is actually that you take, consent. Usually it's not, honestly, it's market practice is not really, to worry about this. But what we see a lot of HRMS softwares also do is they usually have some consent pop up or some layer, because the users employees might be, when they're logging into the systems, agree to that data collection. So that's a way to kind of show that notice and say that data is that's employees' data that's being collected.
Perhaps we can move forward.
Yeah, I'm mindful of the time. So, but we'll also pick up only some of the key themes because, like one could just go on and on this. But I wanted to next touch upon the theme of publicly available data. So this is an interesting exception, particularly businesses that might be collecting or sourcing data from the web for AI training. Now, there are two types of exceptions here. If you are processing any personal data that's been made public by an individual herself, that kind of data is exempt from the obligations of the law. And if you've made data public under some law, for example, court records are made public, land registry records are made public. If any of that is made public under the law, that's also fair game. It won't have the same protections that other that other kinds of data have. This is not a blanket exception. I don't think this is meant to be a carte blanche that you can simply use all and any data that's out there. It's only when individuals make the data publicly available themselves, or if there is, a legal obligation to do that, is where you can really rely on this exception. But I wanted to take another example to drive home this theme. So now let's say there's a company that's using a predictive health risk analytic company. Now you're using an AI-driven tool to identify early signs of depression, anxiety, other health risks. So, but at this stage, let's say you're at model development stage, or you're validating or testing a model. Now you've sourced a lot of data, let's say from public profiles on social media, wellness forums, Reddit forums, fitness communities, whatnot. Now, for this kind of data, the question is whether you can really rely on the exemption for publicly available data. Now, so what happens here is, because the law says it's only data that is made publicly available by an individual, one must make sure that, so if I've written something in a blog and I've published it, of course, that's fair game. That's a straightforward example. Similarly, if I have a public profile on social media and I've posted publicly, anyone can read my posts and messages. That should also be okay. But let's say if I have a private profile, I've curbed, very access controlled. I've curbed who are my followers. I've curbed who's able to view and access my profile and my messages and my posts. In that case, you can't actually assume that if you're connected with that person, you can simply go ahead and publish their data or um, process that data freely. So it's not a carte blanche. One will have to look at these specific guardrails on when whether something can be thought of as publicly available or not. Similarly, I mean, you may have multiple sources. If one of those sources is hospitals, that's definitely not being thought of as publicly available. For that, you'd have to have some kind of consent notice baked in. It could be through those data licensing agreements, or if it's specifically like, in one of our earlier examples, where we've asked the hospital to specifically collect some data from us. So making sure that we have that consent and notice there. So the exception is only where data is completely made available publicly by an individual. I think I'll just maybe spend 2 more minutes on the data breaches theme, and then I think we can take questions. And I know we have only 10 minutes left. So the next theme is on breaches, like I've said. So in case of a data breach, what the company needs to do is inform affected individuals promptly. They have to give individuals details of the breach, potential consequences, mitigation measures. They have to inform the board also immediately. This can be an initial notification that you provide. It doesn't specify a timeline for either of these, but it does say that you have to provide a more detailed report, a final report within 72 hours, covering the facts of the breach and remedial measures. A lot of the industry has raised concerns with this because 72 hours is not enough time for remediation and for actually having all details around a breach, especially in complex ransomware and other scenarios where, it takes time to investigate. But right now, that's the framing in the rules, at least that's provided to us. So it would mean relooking your internal breach response protocols and practices, making sure you have practices and protocols, SOPs in place so that you're not scrambling when there's an incident. So we run a lot of tabletop exercises and simulations also for companies, and this is our favorite one, where let's say you're a health platform and you're providing some solutions and services. Let's say you've gotten just an anonymous email in the morning. And the email to the DPO says that your patient records, including health conditions, all of this has been accessed, is going to be leaked online. The attacker shares a small sample, let's say with 10 databases, but they actually redact a lot of the information there. So you're not able to identify at this stage if it's a random tip, totally random. You're not able to correlate this with whether this is your data or not. And it's a ransomware situation where they said, pay me 2 million crypto, otherwise we'll make all this public. So the questions to discuss then become, is this a breach? Breach really means unauthorized processing of data, any disclosure, acquisition, sharing, use, alteration, destruction, loss of access that's affecting the confidentiality, integrity, availability of personal data. While this last part is very common, the CIA triage, confidentiality, integrity, availability, but the first part of this breach definition is fairly wide, any unauthorized processing. So it would mean that any instance we have a severity matrix laid out, we do all of these fact scenarios that play out so that our internal teams know what to do in case a tip like this comes. And the same instance, we'd have to evaluate at what point does it become a breach, at this instance or later on when employees are unable to log into the systems, or when there is something credible. Let's say in these samples you actually had the names and there's something identifying that data set to your lab reports or your kind of data. So making sure that one is putting in place these internal structures. So that's the last theme that I wanted to touch on. Maybe I'll pause here and take a couple of questions. These were some broad themes, but happy to take questions on these or on any other themes also that you'd be interested in.
Sure, Srinidhi, thanks for that. Actually, we don't have a lot of questions, but perhaps I'll just pose two to you. First is, if a company finds any personal email address made available online, can they use it without complying with the law?
If they receive a data set that's online without knowing the provenance of it?
Yeah, it's a personal email address that they've just found online. From the nature of the question, it looks like it could come from a data breach, or perhaps
Or
no.
legitimate sources as well. So I think, let's say if it's on LinkedIn and I'm also, a connect of that individual on LinkedIn, and I've made it such that my email address is visible to LinkedIn connections, that should be okay. But if it is on a database, which is actually completely, we're not sure if it's coming from a breach, we shouldn't be using that data. It's kind of an illegal source. And if we're aware that it's an illegal source, that's a problem. But yes, if it is a credible source, or let's say I've met someone at an event and we've exchanged cards, then I'm okay. I'm good to share, send them an email. But in other scenarios, typically one would have to be a little more mindful. I know it's simply not market practice to dig through into the provenance of the law. And I am also aware that this is basically business contact information. Once, let's say my email ID is out there publicly in so many different forums. So really, I think it's the intent with which maybe business information one would pragmatically take a slightly different view. Under the law, there are no real, whether it's a email ID, it's a phone number, it's your health records, it's all treated at the same pedestal, really, that you must provide notice and take users' consent for it.
Thanks for that, Srinidhi. Perhaps the last question we can take, which is, are there any sector-specific regulations for Medtech that govern the processing of patient information by medical device manufacturers, such as any adverse event reporting requirements under the CDSCO?
CDSCO does have some regulations and restrictions around this. I would have to check and come back on this. Not specifically, not aware of what for breach reporting, what might be the specific requirements here, but there are some guidelines for medical devices generally. But yeah, this might be something we'll have to check and come back to you.
Sure. As we have time, Srinidhi, maybe we can just take one more question and then we can wrap it up.
Sure.
So the question is, if the employment purposes or related exceptions or legitimate use apply to candidates who share personal detail on the online portal of the company, or they apply only when the applicant is found suitable for the position and is issued the offer letter?
So the question is whether when employment purpose will be applicable?
Yeah, only at the stage of application or once they've received the offer.
Right. So typically, it's also when, so I think the law doesn't say one way or the other. It simply says that for employment purposes, particularly when you're looking to safeguard an employer from, let's say, loss of confidentiality or breach of IP, those are circumstances where one needs to really, use that employment purpose. But I'm inclined to read it a little more widely to also include recruitment scenarios. I think in those scenarios, it would anyway, it's kind of, it's not as though there's some background data collection. It is definitely, I've asked the candidate to share some data. Ideally, I give them a privacy notice and say how my data is, how I'm going to use their data, and then they provide that data to me in response to my query. So, I'd be in either, whether you're looking at it as employment purpose or you're looking at it as either consent or voluntary provision of data. I think you could justify it under one of those, because See, employment purpose is typically when that employment relationship has started, although I'm inclined to read it in a little more wider fashion.
Thanks for that, Srinidhi. There were a couple of other questions, but perhaps we can take them up offline, and we can, maybe just reach out to them people. Thanks.
Yeah, I think that would be a good sort of at least progress from here. I think Srinidhi, if you can just drop, I don't know if it's possible for you to just drop your email in the chat.
Yeah.
In case somebody has a question which went unanswered and you could not take it up, or some specific queries that they may have, they can directly reach out to you. Thanks, wonderful. Thank you for that. And I think just the one last request from our side, please take your mobile, please rate our event. We can only improve if we have some feedback from you, so we can do this even bigger and even better. Thank you, Srinidhi. I think just the number of questions indicate how much of interest there was in the session, and how good you were at your subject. Or, thank you so much. Yeah, everyone. Thank you.
Thank you so much. Thanks for having us. Bye-bye.
Bye.